still.
Okay, we're starting live on YouTube. 1 second. All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning, council. We have 3 cases on the calendar this morning. I will call the first case, CORTEZ Williams versus United States. Ms. Milton.
Good morning, Your Honors. I would just like to reserve 2 minutes for rebuttal. May it please the court, I'm Monica Milton on behalf of Mr. CORTEZ Williams, the appellant in this matter. Mr. Williams' convictions are propped up by impermissible propensity evidence. Therefore, he asked this court to reverse his convictions because the admission of other crimes evidence in the form of a 911 call was error, and that error was not harmless. As this court is aware, over the objection of Mr. Williams, the government sought to introduce other crimes evidence in the form of Doris's 911 calls. In the call, she could be heard saying, "These 2 guys shot into somebody's house a couple weeks ago." The trial court declined to allow the call in under Drew, but did allow the 911 call audio pursuant to Johnson. For the
Can you tell me, counsel, I'm sorry, but was the jury instructed on how to consider that evidence? Were they given a limiting instruction? Why is that so hard to say?
Yes, the jury was given a limiting instruction, and I can read it if the court's interested in the content.
I mean, I think we're pretty familiar with what it says. We reviewed the record, and the jury was pretty specifically told, look, you cannot take this this statement that these guys shot up another house for its truth. She has no basis of knowledge, right? She wasn't a percipient witness to that event. And so this is just for you to understand why she's calling 911 when 2 people show up on her porch at her front door. I think that was pretty clear. So am I misreading what the jury was told?
That's what the jury was told, but under Johnson, this call was the content of the call was other crimes evidence, and it was not admissible under Johnson because it does not assist in proving the charged offense. So in essence, it's only proving that she called 911 initially, but it doesn't overcome the prejudice of the jury hearing this January 2016, there was a shooting, and you're not to speculate, but it still doesn't, the limiting instruction actually bolsters Doris Stevens' credibility by giving a date and sort of proving that she actually knew that there was something going on and that someone had shot into another home. So
is your point that no limiting instruction was possible then?
What's that?
I mean, is your point that no limiting instruction would have worked under the circumstances? I mean, because it seems like this limiting instruction was pretty carefully crafted. So if this one wouldn't do, then you just had to keep it out. Is that your argument?
Yes, because it's the fact that there was, that Doris says there was another shooting, and the case before the jury is a shooting case, it is extremely prejudicial, and it's only going to show why she called 911. But then in the limiting instruction, it says there was a shooting on January 16th, but you're not to consider that. So essentially asking to unring a bell. And so it invites the jurors to look at Doris, seemingly more credible than she is, because she says they're going to shoot, these 2 guys shot into a house a couple weeks ago. And then the case before them is these guys shot into my house. So it invites the jury to believe that there is a criminal propensity for Mr. Williams when she refers to they, because she does identify Mr. Williams as the shooter. the jury would be confused, or at least it's extremely prejudicial to Mr. Williams for the jury to hear that there was in fact another shooting, even if the limiting instruction said, don't consider this for the substance. She had no idea. It still validates her statement, and it's extremely prejudicial.
It's only prejudicial, I suppose, at all. The only way it could be prejudicial is if the identification of Mr. Williams is credited. Since if it's not credited, there's no reason for it to have any prejudicial effect at all. Isn't that correct?
That's true. But if you look at the nature of the instruction saying that there was a shooting on January 16th, and the case before the jury is a shooting case, the similarities of the crimes could cause juror confusion. And because he was convicted of the crimes charged, the jury did believe that Mr. Williams shot into the receiving's home.
Right, but the report that there was a shooting on another day doesn't say anything about whether Mr. Williams was the shooter. It doesn't prejudice the identification of Mr. Williams. And what it did do, the relevance that it had was substantial, was it not? That's what the judge found. It was substantial to explain the otherwise difficult to understand actions of Doris, I guess we're calling her. Doris, right? Calling her by her first name.
Sure. Doris, the distinction that Johnson, or the reason that this is admitted is under Johnson versus United States. And Johnson is limited to proving the charged offense. So it isn't admitted to prove identity or to bolster identity. And so even under Johnson, this evidence is not admissible because it's not.
Do you want to talk about the identification?
Sure, I can talk about the identification. So the Supreme Court recognizes so well that an identification procedure can be so suggestive that it triggers due
Counsel, I'm sorry to interrupt, but there seems to be a little bit of an issue with your microphone. So I just want to make sure you're coming in and out. So before you get rolling, I just wanted to let you know.
You hear me better? No?
Yeah, thank you.
Okay. So it's Mr. Williams' position that the trial court erred by admitting suppressed identification evidence in violation of Mr. Williams' right to due process.
Can I stop you right there and say, and just make sure I understand, the court erred in admitting suppressed identification evidence? So your position is that the trial court had suppressed this identification pre-trial?
Yes.
And what do you point to in the record for that? I'll confess, having read the transcript from the June 1st proceeding, which I assume is what you're referring to, I found the conversation extremely difficult to follow what the court was doing.
Well, so with respect to the motion to suppress,
with respect to, I'm sorry?
The motion to suppress the in-court and out-of-court identification evidence, the issue before the court was both in-court and out-of-court identifications related to the photo array that ultimately we learned that the government lost. So the initial motion to suppress was regarding the suggestive photo array, and that there were people that were in the photo array that directed your attention to darker individuals because that was the description she gave. But in the copy of the photo array, you can see that there are just two individuals who are significantly darker than the rest of the individuals in the photo array.
But isn't it clear that the judge is saying, basically she's granting the motion, whether it's sanctions or suppression? She seems to think it doesn't really matter what you call it. She's not letting in evidence about this array because she can't figure out whether it's suggestive. And and so if you're saying if your argument is that she suppressed this evidence plus the subsequent identifications that I agree were, were raised in the motion, but how do you get around that? And how do you get around the fact that on page 19 of the transcript, the court is like, okay, well then after, the only remaining question is, does the showing of the photo array taint the subsequent identification? And, that would be the point where you'd hope the lawyer would come in and say, well, yes, and here's why, but the prosecutor says no, and it just gets dropped. So it seems like that isn't decided.
Right, and I think
Or it's decided against him, I don't know, but.
Well, it's raised, but it's not decided. And in that context, that's the error that the trial court committed, because the trial court has a duty to make those determinations before allowing Doris to testify as to her identification of Mr. Williams. So this court directs that even if you don't find an identification procedure suggestive, that you move on to the reliability prong of the analysis and still make that determination, just in case it reaches the appellate level and the court disagrees.
But trial judges are supposed to work with the advocacy that's presented to them, right? And so you have the judge pinpointing what would seem to be a really important question. Is this identification, right? I mean, if you look at the record in this case, you have the eyewitness, you have contemporaneous records of what the eyewitness describes the shooter to look like in the 911 calls. And it's pretty skimpy, right? Black man.
Right.
Black coat.
Right.
And then, initially when they come to the door, she says the light-skinned guy has a mustache and beard. And suddenly in the 911 call after the shooting, the dark-skinned guy has the mustache and beard, even though later on she says he's wearing a mask covering the bottom half of his face. So how does she know he's got a mustache and beard? I mean, this is a questionable identification. She's then shown a photo array, right, which you argue is suggestive, but now we can't tell because we don't have the original array. She doesn't make an ID from that array, right? She thinks that maybe it's one of two pictures, and she's apologetic that she can't make an ID.
Right.
And then after months, she sees a Facebook picture or some photograph from social media, and now she's certain. That's a problematic ID, right?
Right.
But where's the argument? I mean,
well,
it's not there.
The argument was in the initial motion to suppress, and the judge—
There's one sentence in the initial motion suppress at the end that says, please suppress all identifications out of court and in court.
Right.
And then in the passage that Judge Beckwith was just pinpointing, the court specifically asks, right? I don't know how you deal with this. Does the showing of the photo array that she saw taint the subsequent identification? It's the $64,000 question.
Right.
And the government says, no problem here. And defense counsel is silent. And then at trial, the government puts an in-court idea in, and defense counsel says, no objection, subject to cross.
Right. But that still doesn't eliminate the trial court's duty to make sure that these eyewitness—
My point is the trial court needs to have lawyers who are advocating for their clients. Is the 23-110 been filed in this case?
No, there hasn't been one yet. But to the point of whether or not there needs to be this identification evidence, it's still before the court, and the court does raise the issue and still sort of doesn't decide. Now, although the perhaps it wasn't litigated to the full extent, it was still raised and it's still before the court. So it should have been decided, and this court has directed trial courts repeatedly to make those determinations. So beyond the duty of a trial lawyer to advocate for the client, but there's also the duty for the trial judge to serve as its gatekeeping function and make sure that they have the right person on trial.
Okay, I think you wish to save a couple of minutes for rebuttal, and we'll give you that time. Let us hear from counsel for the government.
Good morning. May it please the court, Patricia Heffernan on behalf of the United States. Picking up with the second issue, the identification, I agree that the conversation when the court issued its ruling was quite confusing, but I think it's also quite clear that both parties and the court understood that what the court was doing was granting the defense request for a sanction excluding the photo array. That was the basis of the ruling. And I think if you take a step back and look at how things subsequently played out, in addition to defense counsel saying that he had no objection when the government elicited this identification, if anybody had understood the ruling to include anything more than the photo array, exclusion of the photo array, first of all, the government wouldn't have elicited the identification in contravention of any ruling. Defense counsel would have objected and the court would have intervened. So the way the subsequent litigation spun out, it's clear that everybody understood that the only thing that what the court had done, regardless of her inartful referring to suppression, the court was granting the motion for sanctions. And on June 5th, the court made it clear.
Can I just go back though? I mean, on page 20 to 21, I mean, the court says, my inclination is to deny the motion for sanctions, to grant the motion to suppress, and not to allow, or well, to grant the motion to suppress and not allow the identification, to not allow the identification in. And I guess I'm granting the motion for sanctions to the extent that I'm not allowing it. And so, I mean, that sort of points you in one direction. She for sure, she says other things, but the docket also says, I'm granting the motion to suppress, right?
Yes, correct.
It doesn't say anything about the motion for sanctions on the Rule 16 grounds. I mean,
Correct. Yeah, I
should-
mean,
should we go back and, I mean, do we need a record remand to figure out what it was that the court ruled?
I don't think so, because if you look at, first of all, the docket entry is made by the clerk, so that's not going to have any legal heft. It's really what the court had to say at the time it ruled. And I agree, the court was interspersing this language about suppression, but in substance, what she was saying was, I can't rule on this motion to suppress because I can't decide the question of suggestivity. And so, you know, and so that's the substance of what she's saying. And then she says, and because
Right,
I can't
sorry.
rule on this.
If she's saying I can't rule on suggestivity, but arguably she's sort of presuming suggestivity, right? I mean, they're talking about the Xerox of the photo array, and they're saying, well, you know, these two people do stand out. They are much darker. And, you know, the inference being like, when you Xerox something that's dark just becomes darker. It's not like the Xerox is going to have that effect on two random photographs. If she's effectively presuming suggestivity, should she have made a further inquiry into reliability, particularly since she was, you know, astute enough to realize this might impact other identifications?
I disagree with the premise, Your Honor. I don't think it's accurate that she said that she thought that there were two photos that were darker. She thought Judge McKenna on January 22nd described the array as having four people who were darker complected. And in fact, on January 22nd, she said that if that's your primary argument, that they're unduly suggestive, there's no basis for that conclusion based upon this array. That was at page 6.
Yeah, but I
5
thought the trial judge actually made her own inspection. I thought she wasn't aware of what Judge McKenna had ruled. And on page 12, she says, it's clear that this is on the June 6th proceeding. It's clear that some of them at least are substantially darker than others. And then she says, I don't know if it's just 2, but
she says looks like 4. She said,
right.
She says looks
And
like
then
4.
she's saying, I can't see their faces. I can't see if they've got facial hair. And then she gets into that more on
Yes.
page 18, saying, look, if your client has a mustache and nobody else does, that's going to be problematic.
There's no question that she discussed the differences in the photographs. That the defense argument was 2 people look darker. 2 different judges says no, it looks more like 4. So I just wanted to make that clear that there's no finding that 2 people were substantially darker, because both judges thought that the array looked like it was at least 4.
What about,
Does ha-
I'm sorry, Judge.
Oh, go ahead,
Clifford.
Judge Pickler.
Okay. What about the passage on page 19 that I referred to before, where the judge said, kind of has ruled here, and then the only question is, I don't know how you want to deal with this, but does the showing of the photo array that she saw taint the subsequent identification? Doesn't that sort of indicate that there's some that she says this is a question, we have to figure this out? Why would it affect the subsequent ID if she didn't kind of at least assume a problem with it? And also in that regard, if she's getting that close to the issue, basically asking the question, and if it's in the written motion, albeit in a skeletal way, isn't the purpose of the preservation rule satisfied? I mean, she's apprised of it, it's raised, they're actually discussing it. What more is there, for defense counsel to say?
Well, a few things, Your Honor. I think the judge touched on this very briefly and discarded it as an issue. Defense counsel stood silent. He didn't say, yes, that reminds me, we'd also like suppression of this photo array. And my theory is, let me explain it, let alone give a theory. There's no argument here about how that initial array could have tainted the Facebook identification.
But let's play that out again. Like, I mean, what does counsel get out of suppressing the array, right? I mean, this is effectively a 1 witness case.
Yes.
And the whole question is, did that 1 witness have the ability to identify Mr. Williams? And arguably the array where she doesn't make an ID and is apologetic about not being able to make an ID is a component of making a mistaken ID case, right? So,
yes.
So counsel seemingly it seems to be doing everything that he can at trial to pursue a mistaken ID case, and yet doesn't do precisely the thing that he needs to do, which is to either keep the ID out or put on an expert to show the jury why the witness could be wrong. I'm trying to understand under what conceivable notion of effective assistance could counsel have wanted to keep the array out? Why is this something that he wanted to do? He should have wanted to get the identification suppressed.
The answer is a bit long, if you'll bear with me. But first of all, I think if counsel thought that he had a taint argument to be made with respect to the Facebook identification, he would have made it. This is experienced counsel. And this is the Facebook identification comes 2 months after the photo array. We know the photo array. We don't know, we know that there was not a certain identification with respect to the photo array. She just said, could be 5, could be 7, looks more like 7. Whereas this Facebook picture is a definitive ID. She's certain. We don't know in the record how the Facebook photograph compared to the photo array. We know that this is 2 months after the photo array. So there's no reason to think that she's kept in her mind all these 2 months exactly what this photo looked like. She didn't have the defendant's name. And so I think if counsel could have made a taint argument, you would have seen it there. And now I'd like to get to the kind of the heart of the matter, your question about
Can I
was he
can I
doing?
take it in
Challenge it.
parts though? I'm
Sure.
sorry to interrupt. I know
Nope.
you said you had a long explanation and I do want to hear the second part.
Yes.
But as far as her confidence with the photo array, I mean, what you seem to have as it is an inflation of confidence over time, right? She's shown his array, an array with his photograph in it, and is not sure that he's the guy, and then finds a photograph that has him in it and suddenly is sure. And not only is she confident at that point, she's able to give descriptive features that she's never been able to give before, right? So I you know, this issue of if there had been a taint defense to have, I mean, this reminds me of Jennifer Thompson. Like this seems like classic taint defense that counsel is not making. So I mean, what's your response to that? Generally, witnesses don't become, the point in time that you want witnesses to be confident is immediately after. What's their confidence ability immediately after the incident to be able to describe the person and to identify the person, not 3 months later?
Well, she explains in her 911 call when she's challenged about why she didn't describe the defendant. She says she was in a rush to get the police to her house. So I think that tells you, you know, that is an explanation for why there isn't a description in this 911 call. She does then later describe the defendant as having very dark skin, a bony face, distinctive eyes, and a very big nose. So
she doesn't say anything about the nose until after she sees the photo array. Am I mistaken? I didn't see anything in the record to indicate that she described his nose at all before she sees the photo array.
I think that the record is a little scant because the detective, the lead detective, did not testify, and that the detective that presented the photo array didn't testify until trial, and of course nobody asked him about that description. But the descriptions in her interview were provided to a detective who was hospitalized and didn't testify. So I'm not exactly sure what the dates are, because in an ordinary case, a detective testifies about the various interviews and the identifications that were made, and we don't have that here. With respect to the theory.
Sorry, if you want to get back to your other point.
Why this spun out the way it did. So as I said, you know, I think if there had been a taint argument to be made, we would have heard it from this experienced counsel. The theory at trial, the defense theory at trial, as articulated in the opening statement, was that there was a funeral on April 9th. Jacoby Williams' brother had been killed. His name was Rashad Tate. And that Doris Stevens went to that funeral knowing that she would see Jacoby Williams on April 9th. And that not only did she see Jacoby Williams, she saw the appellant there. And thereafter, when she found this Facebook photo with Jacoby Williams and appellant together in the Facebook photo, and appellant is a dark-skinned man, having seen him also at the funeral, that's why she mistakenly identified appellant as the shooter. The problem was that this blew up on cross-examination of Doris Stevens when she testified that the appellant was not at that funeral. So the photo
that he wasn't there, or that she didn't see him there.
Well, she says both, but basically, regardless of how, you know, what came across was, you know, she didn't recognize, the argument that she picked the Facebook photo because she saw appellant at the funeral with Jacoby Williams then fell apart.
Right.
But so
the better argument was she picked him she saw him in the photo array, but the photo array had been excluded. And so defense counsel didn't have that argument and went for an argument that he then didn't substantiate at trial.
Well, I think if the theory is that this is all spinning out of the seeing appellant with Jacoby Williams at the April 9th funeral, that wouldn't have explained the prior array. It was the photo array was the only identification that defense counsel couldn't eliminate because it preceded the April 9th funeral. So that's why I think that was what the defense strategy. Unfortunately, it just didn't play out because Doris Stevens on cross-examination testified in a manner that defense counsel didn't think she would. Moving
Counsel, oh, I'm
Yes.
sorry, I don't mean to cut you off, Ms. Heffernan.
We're
We've
out of
gone
time.
through 15
Yes.
minutes, but go ahead. You were about to say something.
Time really flies. I was just going to turn to the 911 issue just very briefly to point out that, not only was the jury instructed that this is not admitted for the truth, but it was also instructed, it was a very strong instruction saying that there was no information at the time of the call that the appellant was involved in the shooting. There was no evidence before the jury. The jury was not to speculate about it. And as the court recognized, it was important evidence for any number of reasons explaining her action and her focus on appellant on the porch. And that's how the government argued the evidence. At no point in trial was this evidence, either any suggestion that this evidence was substantively before the jury that appellant was involved in any way in this shooting. If there are no further questions, we'd ask that the judgment be affirmed.
Thank you.
Thank you.
And Ms. Milton, we've given you 2 minutes for rebuttal.
So I'd just like to address the issue that Doris was very certain in her identification. Her identification becomes increasingly specific as time goes on. However, she's given a picture of Mr. Williams from someone else, her niece, she says, in beginning of May. There's no explanation as to why she doesn't immediately say, this is the person who shot at my house. Weeks go by, and then she makes this unequivocal identification, as she claims, of Mr. Williams. So in the intervening weeks, we don't know what types of suggestive behavior occurred to induce that identification, but we know that she was given this picture in the beginning of May. She was in constant communication with the detective, yet she doesn't say, this is the picture, I finally found this person.
Counsel?
Yeah.
She's crossed on this though, right?
She doesn't, she's crossed on, she does say when she, but she doesn't talk about what happened between the time her niece gave her the picture and the time that she made the identification.
Well, did defense counsel ask her?
No. So this is, again, shows that she's made this identification. She does talk about the fact that she had this picture in the beginning of May, but as the government argues that there was this immediate identification, there wasn't. So she was susceptible to the suggestive nature of receiving this picture, and perhaps even a taint of rumor and innuendo, which swirled around Kobe throughout this entire trial. And so in effect, this is a case of essentially guilt by association. And Kobe's name is brought up repeatedly throughout trial, and he's not on trial, but the government continues to bring his name up in order to try him by proxy through Mr. Williams.
Ms. Milton, can
Ms.
you tell me what you think trial counsel meant by no objection subject to cross-examination? What does that mean?
I think that he wanted to attack the credibility of her identification in order to undercut any understanding that there was an actual equivocal identification of Mr. Williams. So
Was he waiving any objection to the in-court ID?
I think that's a position that one could take, but that doesn't eliminate all of the things that happened before trial that impact the day of trial identification. So essentially, even if you were to get the in-court identification, Mr. Williams, a Black man sitting next to his two white counsel, trial counsel, it's already a suggestive situation to begin with. And whether or not she was able to identify Mr. Williams at trial is different than whether or not she actually, on the day of the shooting, saw Mr. Williams. And I think that that's the bigger issue, and that's the problem with Ms. Stevens' identification of Mr. Williams, is that and beyond that, her ability to perceive and remember is also a question, because she knows of Kobe. She goes the night of the shooting to Kobe's Facebook page and gives the police a picture of Kobe, and then a photo array is shown to her 2 days later. She can't identify Kobe. So there are some real issues with her ability to perceive, and I'm not suggesting anything nefarious, but just that there's severe questions as to whether or not it's her identification can be viewed as a reliable ID.
Thank you, Ms. Milton. Thank you, counsel. The case is submitted, and in due course, you will be hearing from us. We'll call the next case. Okay, we're calling the case of NICO Enterprises versus Council of Co-Owners of Town Square Towers Condominium. The case is submitted, and in due course, we'll be hearing from us. Call the next case. Thank you. Counsel, did you hear me call the case just a minute or two ago?
This is Mr. Howell. I did hear, Your Honor, yes.
Good. Okay. Mr. Howell, we're ready to hear from you.
Counsel, if you
Excuse me, can I just
counsel, if you are streaming from
ask the
YouTube,
courtroom clerk? I'm hearing feedback from seconds before.
Yes, counsel, if you can turn off your YouTube stream. Thank you.
All right. All right. Thank you, Your Honor.
Howell, you may proceed.
Thank you, Your Honor. And I'm sorry if I missed the procedure for it earlier, but is it permissible for me to reserve 2 minutes for rebuttal?
Yes, you may.
Thank you, Your Honor. If it please the court, my name is Danny Howell, and I represent the appellant NICO Enterprises, LLC, with respect to an appeal from a grant of summary judgment with respect to the entry by virtue of a condominium easement and the refusal to consent. The court's quite clear in its description below that the basis for the plaintiff's claim was that defendants materially breached their contract by refusing to consent. That's a quote from the order. And that the court's determination that there was a breach of the contract was by virtue of its finding that the defendants determinatively affected the plaintiff's ability to enter and complete the repairs. The word determinatively means, I think in this context, conclusively, finally. And the record is replete with statements from NICO Enterprises in writing and otherwise that no one was impeding access, but there was not going to be any grant of express consent. And there is a legal principle that overlays the issues on this appeal that's important here. When a holder of an easement is granted an access without a requirement of consent, there is no requirement that consent be given because the holder already has it. But if, with that type of an easement, the subservient landlord or owner rather does in fact give consent, and especially consent in writing, that can constitute a potential waiver of rights. That's exactly what we had, by the way, in the Delmarva Power and Light case that we cited in our briefs. The electric company had an easement to trim trees. They came on a particular date, they wanted consent wasn't given. Later, they killed someone. And they argued that responsibility should be shared, either because consent should have been deemed required or because there should have been deemed a change by virtue of behavior in the contract itself. The court said, we understand you have a practice of seeking consent, and that's admirable. but you already had consent by virtue of the provision of the easement. And there is no basis to say that there's been some sort of mutual either revocation or modification of the contract provision.
Well, Mr. Howell, your adversary argues and argued below that Dr. Blather's behavior belied her consent and interfered with the council's ability to enter her unit as a practical matter. Is there a dispute about that? And if so, how do you respond to that?
Well, Your Honor, there was never a time when anyone on behalf of TST, if I will, appeared to enter and do the work they wanted to do. What there was a clear statement in writing, which was consistently made thereafter on the part of Dr. Blather's attorney, that if you do the work, and we're not denying you access, but if you do it and you cause damage, then we may hold you liable. That's the conduct. That's the conduct that TST objected to.
I think one example of conduct to which that was put before the judge on summary judgment was what has been characterized as Dr. Blather's ejection of a man by the name of Paul Rousseau. Would you like to speak to what you understand to be the undisputed facts about, or the disputed facts, if you think there are facts in dispute, about that episode?
Well, Your Honor, there's no dispute that the man came to inspect, and the question to the man was, are you looking just at common area pipes, or are you looking at my pipes? And he couldn't answer. She asked him to leave. That was an inspection. Why did he come to inspect? That did not impede anything. I'm sorry.
Did he explain to her why he came to inspect?
He said he hadn't made a determination as to what pipes fit in what category. And beyond that, he wasn't there, Your Honor, with workers ready to come in. And
well,
again,
the word a little bit, counsel, isn't that a little bit unrealistic? I mean, you know, you'd like the condo to have perfect plans of all the plumbing in the building, but at some point they need to come in and have a look around to make sure that they're doing the work that's necessary. You don't just expect them to show up, you know, without ever having looked at anything and just jump into the work and hope that they're working on the right pipes. That just seems not practical or a real world view of how construction is done.
I appreciate it, Your Honors. The court used a word which had to do with finality and conclusivity. I don't know how many times, but it was multiple times that Ms. Dr. Blathers and NICO made clear that they were not going to deny access. If it could be deemed that there was some denial of access when a person comes to inspect initially, it certainly wouldn't have happened in context of doing work. And yes, if they needed to do it, Dr. Blathers would have had to have allowed them to enter. If they said, we're going to enter, notwithstanding you ask us to leave, she would have to have them do it. But the issue here—
Counsel, sorry to interrupt. The premise of my question, and I think Judge Glickman's, is that doing the inspection is part and parcel of doing the work. So by asking them to leave, they were denying them access to do the work.
Well,
is your point that because of the provision of the bylaws, the workmen, the folks who came to her door, or the people who actually gained admission and then were asked to leave, should have refused to go or should have just barged in anyway? Is that your argument?
No, Your Honor, but if we're living in a practical world, then the fact that there is repeated statements thereafter to say you have access, it cannot constitute a conclusive and final end to all things here. They had the right to do it. If they had said, I'm sorry, you know, we do have the right to do it. Obviously, Dr. Blathers and her attorneys were clear that you do. And if in an initial request to an inspector to leave, and obviously, I don't think there was an attempt to inspect thereafter. It was simply statements that, you know, you are required to consent. If there was an initial statement, then it wasn't conclusive as to anything between these parties. And I do want to emphasize there's a significant potential loss of right here that Dr. Blathers was attempting to preserve simply by saying that her consent would not be given. If that one incident becomes the basis for a conclusive refusal to allow access, as opposed to standing in the door or padlocking it or what have you, then I think it goes far beyond any practical interpretation of the contract.
What is the significance of Dr. Blathers repeatedly telling the council that she was not going to permit them to enter her unit, that she would not consent to their entry or the entry of any of the employees they wanted to go in? Well, it's a little unclear to me what exactly is the significance of that, of those statements in your view.
Well, Your Honor, she made clear that when she used the word permission, it was denial of access, and her attorney did in the appendix at page 147 back in April 2015. That access is never being denied, but we are preserving our legal rights with respect to any damage that might occur. And under those circumstances, the words make a difference in the contract. The difference between permission and access, first of all, it gives more powerful rights to TSP, frankly, but also—
I understand your legal argument about the meaning of the contract and the easement. What I don't understand is what it meant, what this really meant when she was, despite those words, saying to these people, you don't have my consent, I'm not giving you permission. And when she has, I think you haven't disagreed with me, ejected the person who actually shows up to do an inspection. That's not the only incident that the council appears to be relying on, but that's certainly one and apparently the most specific. I just, it's a little unclear to me what she thought she was doing. Oh, that's not the right way to put it. What significance to attach at the summary judgment stage to her repeated statements that they don't have permission, they don't have consent. It has an obstructive quality to it, don't you think?
Well, Your Honor, I respectfully disagree. I believe that when—
If I said to you, look, you're waiving this contract at me, showing me that you have a right to enter into my unit, and I know you have the power to do it because you have a key, but I'm not consenting to your entering into my unit. You don't have my permission. And if you want to come in over my objection and my consent because you think you have the legal right, go right ahead. Maybe we'll see you in court as the unspoken, or maybe I'll call the police as the unspoken subtext of that. That's what I'm asking you about.
Your Honor, again, with respect, the use of the word, you may have access, you have access, but you don't have permission, is something that has to do with a protection of a right. And it's not unimportant, Your Honor.
What is she protecting? I'm still not quite understanding.
Well, it's an illustration in the Delmarva case itself. If through access,
I'm not asking
right,
about the Delmarva case. I'm asking in this instance, what exactly is she protecting?
Your
Because
Honor,
you seem
she's
to be conceding that she had the right to, that they had the right to fix the pipes for the building. So what exactly is she protecting? Presumably if they did that in some sort of negligent way and destroyed her property, she would still have the right to say, look, you destroyed this exam room, or, you destroyed this file cabinet of records. What is she protecting by saying you have the right to come in, but not my permission?
Well, again, first of all, it certainly was expressed to them that while they have access, she is protecting that right. And what I see, and what I see from the case authority at any rate that I think should be potentially persuasive, is that there really is a basis for a claim of shared liability. If a patient is injured for some reason, for something that happens afterward, not just property damage here, then she may face a claim from TST.
But I guess I'm asking maybe the flip side of your legal point, which is, are there cases out there that say, if you comply with this sort of bylaw provision, you waive those joint liability or indemnification provisions? I'm not sure what, maybe I'm messing up the terminology, but if she complies with her bylaw obligations and says, yeah, okay, you have the right to access, come on in, does that mean that if they do the work negligently, she cannot seek recourse against them?
Well, I don't think it's to work out that way. But all I can say,
And
Your
my
Honor,
question
is
is, I'm sorry, do you
I'm
have
sorry.
any authority for that?
Well, Your Honor, what she is exposed to is illustrated by the District of Maryland case. That was a live claim that lasted until the court determined it on summary judgment. And that claim could have been decided differently. The court specifically said that if there had been some sort of a written consent, that there might well be a basis to argue that there was a written agreed modification to the provision in terms of not requiring consent. We live in a world of significant risks, and we do our best to protect them by using language carefully. Access inherently involved permission, but requesting on top of it that there be some additional consent, which then is given voluntarily, not as a matter of legal requirement, exposes one to litigation risks at minimum.
Well, let me ask you.
I'm sorry, Your Honor.
Yeah, if I may, Mr. Howell, I want to ask you two questions before you sit down. The first question is this: what does the record show as to what Dr. Blathers told the condominium council would be required for them to get her permission to enter?
Well, there wasn't anything that she told.
Withholding it for some reason, in other words. What did she tell them was the reason?
The reason that she said was the reason that was said on behalf of her by her attorney in April 2015, which is that we give you notice that any manifestation of harm, damage, injury, etc., will be something which we may potentially hold you liable to. And they say that in the context of you have access, but there's no statement, Your Honor, and I'll be clear. There's nothing in the record in which she expounds the legal principle that I have just argued to you.
So it's not like there's anything in the record that indicates, look, if you want permission to come into my unit, here's the things I want to ask you to do. There's nothing like that.
No, there's no bargaining with respect to consent here, Your Honor. There's an effort to do what she believed, and I believe.
My second question has to do with your counterclaims,
Yes, Your Honor.
or NICO's counterclaims. And I'll focus on the breach of contract and breach of fiduciary duty counterclaims, which I think are the only ones that are really at issue on appeal. The judge granted summary judgment to the council on those counterclaims. I understand it for essentially two reasons. The judge said there was no evidence. Well, they were based on the council's failure to provide for upkeep and maintenance of the common elements and to give advance notice of its construction work. And the judge found essentially that the council made multiple good. When I say found, the judge found no dispute of fact that the council made multiple good faith attempts to complete the work in a manner that accounted for defendant's oral surgery practice and provided defendant with advance notice of construction work. Now, it's not clear to me from your briefs on appeal that NICO has challenged that determination by the trial judge. Have you waived the challenge to that finding?
Your Honor, I don't believe we have. I think we've been clear. I apologize if we haven't been clear enough, but I think we've been clear that with respect to the failure to give notice, the court's wording essentially incorporated its view that a reasonable attempt involved a reasonable attempt to obtain consent. We believe that's the legal error. And Your Honor, if the court cares to have me do it, there is an additional concern that's raised with respect to the limitation of liability provision. And I would say something briefly to that. I know I'm out of time, Your Honor, but if the court wishes me to.
Well, I'll give you a minute to do that, because it's an issue I'd like to get clear on. Go ahead.
Right. All right, Your Honor, the limitation of liability provision applies to enumerated powers under section Article 8, Section 1, with respect to maintenance and repair and other powers. But
To be clear, we're talking about the limitation of liability provision in Article 8, Section 7.
Yes, Your Honor, I apologize for not citing the
I wanted
section.
to be sure I understood. Go ahead.
The section dealing with cost of maintenance and repair in Article 8, Section 1 has a carve out. There is no power to do maintenance or repair absent compliance with notice requirements. That carve out cannot possibly then mean then that notice activity is somehow encompassed in the liability waiver, a liability limitation. That I think is why the court addressed separately the factual finding that it made that the court just raised with me 1 minute ago.
Okay. Thank you.
Thank you.
We'll hear from your adversary, and then we'll give you a couple of minutes in rebuttal.
Thank you, Your Honor.
Mr. Mr. Mugavero, did I pronounce your name correctly?
That was the Midwestern pronunciation, Your Honor. Mugavero is the New York pronunciation.
I'm from New York.
Then you should have gotten it right. Your Honor, good morning, Your Honors. May it please the court. My name is Tom Mugavero. I'm here on behalf of the appellee. I'd like to address two of the questions that the court raised for Mr. Howell. First being, what were her conditions for allowing access? She actually, it is not crystal clear on the record. There is no document, there's no interchange in which she says, this is what I want. However, there are indications throughout the record that what she wanted in order to gain access to her unit was a complete diagram of all the pipes above her unit and in her unit, and a complete indication of which ones were her responsibility, which ones were common. She wanted the association to fix all the pipes, regardless of whether they were common element or hers. She wanted the permission to install a completely separate HVAC system for her unit and cut herself off from the risers. She wanted to make sure that the contractors that were going to do work were properly licensed and bonded, and she wanted to vet their qualifications. She wanted to use her own contractors. There were a number of conditions that she placed on the association, none of which, or at least very few of which, were actually feasible. Not going to let her put in her own HVAC system. We were not going to fix her own pipes and take responsibility for those. There was no diagram. There's no as-built of what pipes were and were not common elements.
May I stop you there and ask you, how much of what you just said was before the court on the motion for summary judgment?
I believe all of it was, Your Honor. And again, I would say that this was not, this had to be gleaned from the record. There was no document specifically saying these are my conditions, A, B, C, D, and E. These came out in various documents throughout the record. I would not want to.
See, I asked this question because I'll tell you what I think is the central question for me. The thrust of your request for and the court's grant for summary judgment is that there's no material dispute, but that she obstructed and interfered with the council's ability to come into her unit to do the riser work. And it's not so clear to me that there really is no factual dispute about that. I'm wondering whether this really has to go to a jury. What are the episodes? One episode, which I'll ask you a question or two about, was this ejection of Mr. Rousseau, that is.
Yes, Your Honor.
It's not clear to me how much we really know about that episode or how much the judge really knew about it on summary judgment. But what concerns me a little bit is that even if there's something to that episode that's pretty significant, it seems to be the only episode that's really been clearly delineated. And she, for her part, can say, look, yes, I was tough and I negotiated and I was insistent, but at the end of the day, I told them, you've got the key. I'm not gonna be able to prevent you, and I'm not gonna prevent you from coming in. And there's talk about how she was demeaning and to the council and its employees and agents. But the allegation, there's a lack of specifics, it seems to me, that I find bothersome, and that leads me to think this may have to go to a jury. That's a broad question, and I'll have more specifics if you what you think on that.
Let me, if I may, let me break the question up into two parts. And one is one part would be the specific incidents of obstruction, of blocking access somehow. You have Mr. Russo's affidavit stating that he went with an employee of the contractor to do the inspection. Dr. Blathers got angry with them and kicked them out.
May I ask you a couple of questions about that?
Yes, Your Honor.
Just does the record indicate? Well, first of all, does the record indicate exactly when he went in, when that occurred? It was April, someday in April.
It was in April, Your Honor, and it.
You know more than that?
I'm sorry?
Does the record indicate more specifically than that?
I am scrolling furiously to that particular affidavit. No, he says it was April 2016.
And do we know anything about whether Dr. Blathers received advance notice that Mr. Russo was coming, or for the purpose for which he was coming, or I'm sort of wondering how this set up, how it occurred.
Right. My understanding, I believe it's in the record, that he went before the office opened. It was early in the morning. It doesn't state specifically that she was given notice. There is no email or memo to her saying on this particular day, Paul Russo will be in your office. However, she was given notice back in March through the town halls in February and March of 2015 that work on her unit was scheduled to be done the weekend of April 3rd. This clearly was a preliminary to that work. The work was going to be done after hours, Friday night, and then Saturday and Sunday. So this would have been prior to that work actually starting.
Okay.
Again, the record does not show that there was a specific notice on this day, Paul Russo will be coming to inspect.
Now, we do know that what her reasons were for rejecting him, right? That is what it's reported, what she said. When I say we know, it's reported what she said to him.
Yes.
What she said to him, do I remember this correctly, did not have anything to do with lack of notice that he was coming.
No, it did not.
It didn't tell me which risers are mine and which risers are yours or something like that.
Precisely. And his response was something to the effect of, I don't know, I haven't looked at him yet. Which goes back to my prior point. It can be gleaned from the record what her concerns and what her requirements were. It's not, again, not spelled out in bullet points.
Now, other than that episode, were there other incidents brought to the attention of the trial judge in granting summary judgment that indicated that she was really preventing the council from getting the work done?
Yes, Your Honor. There was one incident which I believe Maddie Sharpless testified to.
Yep.
That she and the engineer went into the unit to talk to Dr. Blathers and to see if they could work it out. And Dr. Blathers again told them to leave.
Yeah. Now I was going to ask you about that incident because my understanding is that visit related to a water leak in the ceiling of her unit that was unrelated to the project, to the riser pipe project, and that Dr. Blathers asked Ms. Sharpless and the engineer to leave because she had patients. This had come after. uh, which Ms. Sharpless herself said was understandable in her deposition. So I'm wondering how much weight to attach to that incident as an incident of obstruction.
Right, right. Your Honor, I'd like to tie in the second part of my answer, if I may, and that is, as Mr. Howell said, we live in a practical world. The association has a key for use in emergencies, but the reality is that no matter whether it's a commercial unit in the building or a residential unit in the building, if it's not an emergency, they're going to work with the resident to see if they can go in.
Well, let me just, I understand that argument, but I'm also thinking that, you know, I'm not the trier of fact, and neither of course was the Superior Court judge who had this. I'm just wondering whether, you know, citizens on a jury hearing all the evidence could say, well, she was difficult to deal with, she was demanding, maybe we think she was wrong on a number of matters, but we're not sure that she actually obstructed when you take it all into, you know, it's Mr. Howell's point. When you take everything into consideration, they had the legal right to go in, and she admitted they had that legal right, and she admitted that they had the key and could do it, and she basically acknowledged that she couldn't prevent them. So for all her verbal hostility, if one wants to call it that, we can't really say, we the jury can't really say that she obstructed their entrance into her unit. I'm just wondering whether that is a possible, you know, reasonable outcome on the evidence before the trial judge on the motions that we have to recognize.
And I think the answer, Your Honor, is no, that is not reasonable, because that presupposes that before the association could claim obstruction of any kind, it would have to have actually marched in, told all her patients to leave.
Well, they could go in there. No, they could go in after hours.
Even so, they go in after. Bear in mind, Your Honor, this is an orthodontic surgery unit. So there is sensitive equipment that is in the unit. They would have to go in, even if it were after hours. And honestly, we don't know what her hours are, but they would have to go in, move all the equipment, regardless of whether or not they know what it is or how it's to be used or how it's to be protected. Wait, and frankly, risk a breach of peace. They would have to actually start a physical confrontation with Dr. Blathers before they could claim that she didn't do what she was supposed to do. And
Counsel,
again,
is that, excuse me, is that what it really means? I mean, I thought what Judge Glickman was asking, and this question I have in my own head is there sort of a question of fact as to whether her statements that, yes, I recognize you have the right to entry, but I don't give you permission, that she's really kind of giving with one hand and then taking away with the other, right? Like, is there a question of fact that her saying, I recognize you have the right, but actually that right doesn't mean anything because I don't give you permission, is a question of fact for a fact finder to find? And I guess related to that, and I have a secondary question of, you know, if you're saying she's breached the bylaws, doesn't it kind of turn on whether or not she's obstructing your right to entry? And your right to entry could be, you know, in a way that you think is safe, right? Is there some sort of duty of cooperation in the bylaws? That was another question that I had.
There is.
I want to take them in parts, you know, that like, is there really a question of fact when she said, I agree you have the right to entry, you know, whether she really meant it?
I don't believe there is a question of fact. I don't believe she meant it. The fact of the underlying point here is that she did have a duty of cooperation The association is allowed entry into the unit at a reasonable time and with reasonable notice to the resident, or in her case, the occupant. Obviously, reasonable time would require some sort of dialogue. If they're going to change the filters in the HVAC unit and the resident's got a stomach flu, they need to work with the resident to reschedule. You feeling better today? We'll come on in today. She did not, and I think there is no question of fact that she did not enter into any kind of attempt to resolve it. She says, you have a key, but I'm not giving you permission to come in, and I'm going to sue you for everything you've got if you do come in and I think you heard that you damaged anything. To Your Honor's other point from the question from Mr. Howell, there is no case law that says if a condominium resident allows the association and they waive any right to negligence. I would say that if that were the law in the District of Columbia, our clients would be extraordinarily happy and we would cut back on a whole lot of business. That is, I'm not entirely sure I want that ruling to come out. I'm torn. I'll be honest. But she does have a duty of cooperation, and she breached that duty of cooperation by saying repeatedly, "You're not getting permission. You're not going to be. I'm not letting you in." Time is up. If I may finish this thought.
Sure, finish the thought.
At that point, the association really has, and then we get back to the breach of the peace point, the association has a very difficult question to answer. Do we continue to try and work it out with her until it's clear we can't and we need to go to court for an injunction? Or do we just bully our way in and hope to God nobody's there to kick us out and start a fight? I would submit that it may not be as a matter of law, but frankly, as a matter of policy, the second option is not one that we want to encourage. We do not want property managers just blasting their way in because they think the other guy, the resident's not playing ball. We want the association to work with its residents, especially when we're dealing with a professional surgery center. I've gone over time. I can expound on that if the court wishes, but that's the basic idea.
I think we have your argument. I thank you.
Thank you, Your Honor.
Mr. Howell, you reserve 2 minutes for rebuttal.
You're muted.
Mr. Howell,
Well, there I go with the first 30 seconds. I apologize. The court went directly to the record with respect to the second visit that was mentioned and stated virtually by quote from the deposition testimony of Ms. Sharpless that it was understandable at that point with respect to her practice that she wasn't going to be speaking then. If it was material to determine as a matter of fact whether Dr. Blathers meant what she said when she said access, I believe I just heard counsel say that there is a question of fact as to that. I would assume that if we were before a jury, the judge would instruct as to the meaning of certain key terms in the contract, such as access, and whether or not her specific conduct, repeatedly saying there was access, but otherwise being someone they apparently found to be difficult and unpleasant, and they were worried about potential liability, whether that breached a duty to, for instance, not withhold consent unreasonably. If this provision, by the way, had said consent is required, she would still have had a duty not to withhold it unreasonably. And that would be a question of fact. And maybe that is a question of fact, Your Honor. The other.
Well, this goes, I'll just say, this is why I asked you earlier. Did she give reasons to the, or does the record indicate that she gave reasons to the counsel as to why she was withholding consent or what she wanted to happen in order to get her consent? I mean,
yeah,
there is a two-way street here.
Your Honor, there is a two-way street, and her attorney made it as clear as she could that the reason that she was not giving express consent did have to do with concerns about liability. And Your Honor, I heard Mr. Mugaberal, and I listened to the words carefully, that there is no possibility of liability in terms of waiver under these circumstances. in 31 years for myself of advising clients, I don't rely on particular belief as to absolutes. There's no controlling law with respect to this issue, and there's a right to be concerned. And Your Honor, I did have one
Well, there's
additional.
a limit. Well, go ahead. I don't want to prolong this.
I appreciate it, Your Honor. Finally, I did not mention in my opening argument, but there is an issue with respect to assuming that I'm wrong about everything else, with respect to whether there's an abuse of discretion in increasing the Whiteford Taylor firm's fees by about $40,000 based on essentially a late submission on reconsideration of an attorney fee affidavit. We did set forth in the brief, I won't add to it unless the court has questions, that we believe that under Rule 59E, that the court was clear it was applying, that would be an abuse of discretion. Thank you, Your Honor.
Okay, counsel, thank you both. The case is submitted.
Thank you.
And we will momentarily call the next case.
Are you bringing in the next case?
Yes. Okay, we're calling the case of In Re Jinhee Wilde. Counsel, I see, so far here we go. Good. Counsel? You may.
Good morning, Your Honors.
Good morning. You may proceed.
Thank you, Your Honor. May I start by respectfully requesting the right to reserve 2 minutes for a rebuttal.
Okay, please identify yourself for the record.
Good morning, Your Honors. Michael Rohn on behalf of the respondent, Jinhee Wilde. May it please the court. Your Honors, I'm here this morning on behalf of my client, Jinhee Wilde. Our position in the critical issue before the court this morning is whether collateral estoppel should preclude the relitigation of the factual and legal determinations made by the Honorable Ronald Rubin of the Circuit Court for Montgomery County on or about March 30th, 2011. The facts that underlie these various charges date back to 2007. Beginning in May of 2007 on a flight to Korea and various events that occurred thereafter. I'm happy to go into the facts in some detail if Your Honors want.
It's not necessary. I think you can be satisfied that we're familiar with the facts.
I assume so. I know that Your Honor in particular dealt with this issue in this matter when it was first up before the Court of Appeals previously. This matter did proceed to charges in Maryland. The charges in Maryland were certain of the very same exact facts and very same exact issues with certain of the exact same witnesses testifying in Maryland and certain of the exact same exhibits offered in Maryland. The matter
Counsel?
was, yes, ma'am.
We have 50 state bars and we have 50 state bar disciplinary systems. And I think your argument would have a lot more force if we had a national bar and a national disciplinary system. So why is it that whatever happened in Maryland should have any sort of estoppel effect on anything that happened here? I mean, after all, we did not have a reciprocal discipline proceeding here. We had our own hearing, presented our own evidence, heard our own witnesses, and now we have our own recommendation from our own Board of Professional Responsibility.
Yes, Your Honor. Well, what this court has repeatedly said is that the principles of collateral estoppel apply in reciprocal discipline cases. So they are saying that these issues have been fully litigated. So the party, in this instance, the attorney against whom some violation was found, does not have the opportunity to relitigate those very exact same issues. Yet, on the flip side, when those exact same issues and those exact same charges have been heard and have been decided in the attorney's favor, the court suggests that collateral estoppel doesn't apply in that instance. And I would respectfully suggest that the ability for a disciplinary counsel in the District of Columbia to use collateral estoppel as it relates to a determination of a violation as a sword.
Well, let's talk about Robbins, which is somewhat analogous.
Yes, ma'am.
In that case, there's an analysis of privity, and why should that come out differently in the circumstances here?
Well, I know Your Honor is very familiar with Robbins, having been on that panel as well. And there are factual distinctions that are critical from Robbins. First off, I would respectfully suggest that the opinion that the court handed down in Robbins did not only focus on the question of privity, but also focused on the fact that, in fact, in Robbins, the District of Columbia disciplinary proceeding had a full hearing before the Virginia hearing. Moreover, and the court cited not only to that fact, but also to the fact that in Virginia, there was not actually a hearing. There was the record of the District of Columbia hearing that was presented to the Virginia disciplinary panel, and the Virginia disciplinary panel effectively just reading a transcript of what had occurred made a determination distinct and different from the District of Columbia disciplinary body. And if
so that may be one end of the spectrum, but we also have an imbalance here with fewer witnesses in the Maryland proceeding. The disciplinary council sets forth many reasons to have less confidence in the Maryland proceeding than here. Are you saying that it would only collateral estoppel could only be precluded in a situation like in Robbins, where they didn't even call witnesses in the Virginia proceeding?
Well, Your Honor, I think it's a case by case factual analysis, because as Your Honor will recall, the opinion cites to those three components. The court rationalized the question of privity in consideration of those additional factors of a cold record and the fact that the District of Columbia case had already been heard. And I would respectfully point out to the court, and I want to properly quote it, but footnote 7 in Robbins specifically left open the question of whether or not you would defer to final decisions in other jurisdictions, disciplinary proceedings. And the court said, we reached this conclusion under the unique circumstances presented in the Robbins case, specifically that DC had already had a full hearing and Virginia was only relying upon what I would call a cold record. None of those specific instances exist here. And for the court to say that collateral estoppel does apply on other disciplinary proceedings, that necessarily must be a finding, at least implicitly, that disciplinary counsel in the District of Columbia is in privy with their sister bar counsel or disciplinary counsel in other jurisdictions.
No, I don't think so. I don't think so, Mr. Rowan. It seems to me the issue is whether the party against whom the findings of fact or law in the other proceeding are sought to be used had a full and fair opportunity in that other proceeding. It's not so important. It's not really, there'd be little point to non-mutual estoppel. It's not so important if the party that wants to use those findings I mean, well, let me put it differently. In this case, the findings are sought to be used against the party that was not in that other proceeding. That makes all the difference. I don't think there's a serious argument that bar counsel here in the district disciplinary counsel in the District of Columbia was a party to the Maryland proceeding or privy of the party. And that makes all the difference. The council in Maryland was representing the interests of Maryland in regulating its lawyers. Disciplinary counsel here is doing something completely different. It's representing the interests of the District of Columbia in regulating its lawyers. Those interests weren't at stake in Maryland. And other than giving some material in its files to Maryland counsel, the record doesn't indicate that there was any participation by disciplinary counsel of the District of Columbia at all in the Maryland proceedings. That's how I look at it. The key, in other words, the key requirement of non-mutual collateral estoppel, that the party against whom the findings of fact or law in the other proceeding are sought to be used, simply did not have a full and fair opportunity to litigate in the Maryland proceeding, either itself or through a privy. Why isn't that the end of the inquiry?
Your Honor, respectfully, the reason I don't believe that's the end of the inquiry is because what this court has repeatedly said is it's not non-mutual offensive collateral estoppel principles. It's collateral estoppel principles that apply in these cases, and that apply in reciprocal discipline cases. And yes, I will grant you that the evidence that exists that disciplinary counsel participated in the Maryland proceedings is in fact that order which disciplinary counsel achieved and obtained in order to share their file contents with Maryland Bar Council. And that is a component that did not exist in Robbins. There was not any
that's like any witness is subpoenaed or requested to provide evidence and does so. In this case, because the evidence is confidential, they had to get permission from the court. Okay, but I don't see how that makes the proceeding in Maryland, that proceeding effectively brought by disciplinary counsel here. That proceeding was under the control of the Maryland Bar authorities. They decided what evidence they would put on, what evidence they wouldn't put on, what arguments they would make, and so forth.
I don't disagree with the components of the specifics of the actual trial in Maryland being controlled by Maryland Bar Council, but the term privy doesn't just mean that they were actually involved. And in fact, the definition of privy includes someone whose interests are represented by a party to the lawsuit. And clearly, disciplinary counsel's interests are represented by Maryland Bar Council's interests if they're gonna assert reciprocal disciplinary proceedings if there is a finding of a violation by the attorney. And that's what exists in reciprocal discipline.
But it's not, we don't have reciprocal discipline, right? That's not what's going on here. And what I thought Judge Glickman said was, how do you make an argument that the Maryland disciplinary authority is representing the interests of the District of Columbia? And I think there's no argument to be made. It gets back to my point, which is we have 50 state bars, right? And if you decide to get barred in different jurisdictions, then you have to abide by their rules and be subject to their disciplinary procedures, right? And that's what happened in this case.
I would respectfully suggest that in fact they are sharing the same interests when there is a violation found. So why in the converse would it not also be applicable? In other words, if reciprocal discipline applies collateral estoppel principles, as this court has said, then the converse should be true, and that is that the findings and the determinations by a similar disciplinary authority in another state when they happen to be in the attorney's favor are likewise conclusive on those issues. We're simply asking that both sides play under the same set of rules. That is, when there has been a determination of the issues and when there has been a determination of the charges by another disciplinary authority, if reciprocal discipline is going to be imposed upon the attorney, that prior decision on those issues should be the same. And I would respectfully suggest that that's exactly what Robbins left open in that footnote. And what Robbins said is, under the unique circumstances where the DC court had heard the case first and the Virginia court, disciplinary authority was second, and when Virginia was relying on that inferior record, are the critical components as well that went into Robbins, which are not present here. Maryland heard the witnesses that were offered. And I will grant the court that DC heard from more witnesses, but that doesn't necessarily change the fact that Maryland decided at least 5 of the specific factual issues that were likewise tried and charged in DC, and Maryland made credibility determinations on a multitude of the same witnesses, which were directly contrary to the District of Columbia's. It is those findings and those issues that we believe they are collaterally stopped from relitigating and should have been conclusively determined in favor of the respondent in this matter. I know I
I think you
reserved.
wanted to reserve a couple of minutes, and we'll give you a
Yes,
couple
I know.
of minutes.
So I apologize for going over.
That's quite all right. Counsel, Ms. Porter?
Thank you. Julia Porter on behalf of the Office of Disciplinary Counsel. May it please the court. The misconduct in this matter began when the respondent, Jinhee Wilde, stole $1,100 from another passenger who was asleep on the plane flying to Korea. The misconduct started then, but it continued for over a decade. For over a decade, Ms. Wilde engaged in a pattern of dishonesty, which the hearing committee spelled out in some detail in its report.
But it is what one of the things we're here to talk about is the oddity that the bar officials in Maryland looked at the same evidence, or a lot of the same evidence you're talking about, and found otherwise. It's
well, let me start there, Judge Beckwith, because that is not correct. True, there was overlap in the misconduct that we charged and the misconduct that was charged in Maryland, but disciplinary counsel charged Ms. Wilde with additional misconduct that wasn't part of the Maryland record. That included, but was not limited to, fabricating and forging a document by Mr. Tucci, the bank's lawyer, falsely filling out the worldwide checks and sending them to the victim in order to frame the victim and her partner. It included allegations that Ms. Wilde had made false statements to the bank employees. It included allegations that Ms. Wilde had made false statements to disciplinary counsel, and it obstructed our investigation. The hearing committee found that Ms. Wilde engaged in all that additional conduct. Yes.
Ms. Porter, if I may stop you, I think we're aware of that, but the issue is before us is really this collateral estoppel issue, I think. And let's assume for this, and you know, they're only asking, well, just fine. They only want collateral estoppel as to the facts that were found and were addressed by Maryland, not those that weren't. But so let me just ask you the hypothetical. Suppose the Maryland proceeding had involved, it was basically a duplicate of the proceeding in the District of Columbia. Same witnesses, same arguments being made. The Maryland rules are essentially, for practical purposes at least, identical to the DC rules at issue here. But that case was brought by the Maryland Disciplinary Authority, the Maryland Court, and this case is being brought by the Disciplinary Authority in the District of Columbia. Suppose those were the facts, and we don't have all these differences that you pointed to. In your view, would Ms. Wilde be able to invoke collateral estoppel in the
No.
District of Columbia proceeding?
No, she would not. And for some of the reasons that you already touched on, one is that disciplinary counsel was not a party or privy to the Maryland proceedings. We are vindicating the rights of the DC bar. That was not an issue.
May I ask you a question? When you say one reason, is
Okay.
that reason in your view sufficient unto itself?
Yes, because you can't impose collateral estoppel against someone who was not a party or privy. So that one factor alone means that you can't impose collateral estoppel. And the only finding by the Maryland judge was that it wasn't clear, Maryland Bar Council had not presented clear and convincing evidence of a violation of the Maryland rules. And I'd go to the other factor, one of the other factors that the court in Robbins addressed, and that is the inferiority of the record. And I've already outlined some of the allegations that weren't part of the Maryland proceeding, but also the record in the District of Columbia. There were more than 20 witnesses who testified. That's more than double what was present in Maryland. We also had all the a number of exhibits that weren't offered in Maryland. And as the hearing committee and board and the Korean court found, the Maryland court was relying on false evidence and false testimony. That is another difference, which I suggest means that the court should provide no deference or give no weight to the Maryland proceeding.
Let me ask you another hypothetical, if I may. If the District of Columbia Disciplinary Council had been working hand in glove with the Maryland Disciplinary Council, such that we basically had a, let's just simplify this, a joint investigation, and they were working together and consulting and cooperating, and you were meeting with your opposite number in Maryland and saying, all right, here's the questions to ask, and so on and so forth. Would you, such that one, would you say that under those circumstances, collateral estoppel could not apply?
I don't think so. I mean, it would get you closer to being in privity with the party who is bound, but we have a dual sovereignty doctrine where the federal government and the state government can work together, and even if the state or federal government are cooperating with one another, doesn't mean that the other can't bring charges, and that's also true.
That's a double jeopardy issue, but
right.
It doesn't necessarily translate 100% to collateral estoppel question.
That is true, I agree, but in the disciplinary context, that's also true. It's not just the Robbins case. We cited at least, I think, 2 or 3 other cases, Tyden, Peterkin, and there might have been another one, where disciplinary counsel, in our counsel in the District of Columbia, went forward with charges against a lawyer, notwithstanding that lawyer had already been investigated and the other jurisdiction decided not to go forward or dismiss the complaint. We are vindicating, as you stated before, the rights of the District of Columbia. And I guess the bar, which is to protect our public, the courts, and to deter not only this respondent, but other respondents. So the fact that, we were, even if we had closely associated with Maryland, I think that the answer would still be that no, we are not bound by the Maryland court's decision in this case. And again, just dealing with what the Maryland court found, it's clear that the Maryland court was relying on false evidence and false testimony, because a number of those findings, which we've outlined in our brief, were completely wrong and contrary to the actual facts. Unless there's other questions about the collateral estoppel, I do want to, I guess, move on to one of the issues that disciplinary counsel took an exception on, and that is the additional violations of Rule 8.5 that the board did not find. And again, this deals with the District of Columbia. The board found that, notwithstanding the hearing committee's finding that there was criminal forgery, and the board did find the forgery, but they said that it wasn't a violation of 8.5b because there was not a sufficient nexus to the District of Columbia. And we would submit.
What are the ramifications of that finding in light of everything else in this case?
Well, in this case, it wouldn't make a difference. I mean, the sanction would still be disbarment, and the misconduct is misconduct that the hearing committee and board found. There were multiple fabricated and forged documents, some of which had the respondent had affixed false notarization. She offered those false documents as evidence. But it is, I guess, important maybe in future cases where there is a sufficient nexus. It's rare, I mean, I would say it's never the case where we're going to have an eyewitness or a video of a respondent forging the documents so we can, or fabricating the documents, creating the documents, so we can state definitively or prove definitively where that occurred. But in this case, based on respondent's own testimony, there is a sufficient nexus to the District of Columbia. And we've outlined that in our brief, but it includes the fact that respondent created these letters to the bank on her DC firm letterhead and claimed she sent them. She also said that she retrieved the purported bank letters in DC, took them back to her DC office, and then mailed them to her counsel in Korea. So she uttered them to Korea so they could be used in the criminal proceeding there. She also used those in the disciplinary proceedings. All those forged and fabricated documents were on the DC bank's letterhead and had the names of the DC bank employees, and some of them had affixed the DC notary, one of which an employee had in her office. The same with the worldwide checks. It was a DC company. The checks were kept in her DC office. The checks were written on a DC bank. And when she mailed them out in order to basically frame her former partner and the witness, it had a return DC address. We would submit that.
If I may, to follow up Judge Beckwith's question to you, other than getting a precedent that you think will be important or maybe important in future cases, are there any, and I'm using this word deliberately, collateral consequences to such a to our determining this issue in this case? Is that part of the calculus that leads disciplinary counsel to want us to reach this question?
No, other than I guess the collateral consequences in future cases. But in this case, even without the additional findings of 8.4b, which the board didn't make, the only appropriate sanction is disbarment. Not only.
Well, this gets to another question, which is whether you're asking us to, in effect, assume a role of fact finder.
I'm sorry.
Oh, I'm sorry. It gets to another question which I was going to ask, which is whether this request whether this exception effectively is asking us to, as a court of appeals, to assume the role of fact finder.
No, I don't think that is what disciplinary counsel is asking. I think that first, the board reached out sua sponte to address this issue without the benefit of, I guess, the parties addressing it or citing to the record evidence. And it was disciplinary counsel's position that the board, in reaching a finding that there wasn't an additional 8.5b violation, basically disregarded the findings and the evidence that were credited by the hearing committee. But you're correct that it won't make any difference in the sanction in this case. Again, Ms. Wild's theft of the funds standing alone is sufficient to warrant her disbarment. The flagrant dishonesty, which the hearing committee and board outlined, that is continuing to this day, provides another basis. Her obstruction of the disciplinary investigation and her lying under oath at the hearing repeatedly reinforces the need for disbarment.
Might this have some sort of effect on her reinstatement? I mean, as we know, disbarment is not actually for life, it is time limited. So she could apply to be reinstated. Would it have an effect then?
The finding of an additional 8.4b violation?
Yeah.
I don't think so in this case, just because the misconduct was found. It was just labeled as part of the 8.4c and 8.4d violations, not also the 8.4b. So no, I don't think it would really make any difference that if you added that additional label, it's going to change the nature or the quality of her misconduct that she would have to address in a reinstatement proceeding.
Can you may have said this already, and if so, I apologize, but what was the basis of the board's conclusion on this point?
The board said that there wasn't sufficient evidence that showing that the DC criminal authorities could file charges against Ms. Wild for forgery and fraud because we don't know where these documents were created. As I read the board's report, and we disagree in that we think there's a number of reasons why there's a connection to DC that would provide a basis for.
But the disagreement is primarily or exclusively factual. Is that?
Well, not necessarily in the sense that they didn't address the facts or the evidence in the record showing the connection with the District of Columbia. So, and those facts were the ones found by the hearing committee, not facts that we're asking you to find independently. Unless there's any other questions from the panel, disciplinary counsel would submit that you should adopt the findings of the hearing committee conclusions, the additional 8.4B conclusions, and disbar Ms. Wild.
Thank you, counsel. Mr. Rowan, you have a couple of minutes to rebuttal. You'll
You're
have
on
to,
mute, Mr. Rowan.
Mr. Rowan, you have.
My apologies, Your Honors. Mr. Green had muted me and I didn't know I could unmute myself. Still getting there with all these new technologies.
As we all are.
If I may, just briefly, a point Ms. Porter made was Ms. Porter said that the Maryland court did not find by clear and convincing evidence that these incidents had occurred. And she's right to an extent, but with due respect to her, that's not accurate. The Maryland court specifically found this theft had not occurred, not a question of bar counsel not meeting its burden. It was a specific finding that it did not occur and that these forgeries did not occur. It was not a determination by Maryland of a question of meeting its burden of proof. There was an actual equivalency of this defendant we find the defendant innocent as opposed to we don't find that the state met its burden of proof. Just a minor point, but I think it's important. Secondly, counsel cited to the Titan case, and the Titan case was a case though where there was an agreed violation, and the question was what is the appropriate level of discipline? A very distinctual issue from this matter. And I would respectfully suggest to this court that when this court considered Robbins 2 years ago, this court had the ability to specifically say there is no privity amongst disciplinary counsel with their sister bar counsel or disciplinary counsel in other jurisdictions. And the court specifically did not do that. The court specifically said under these circumstances of the hearing already having occurred in the district and under these circumstances of a cold record in Virginia and consideration of the privity issue, we're not going to apply collateral estoppel here. But they specifically said in that footnote 7 that I cited to, we're leaving open the possibility that collateral estoppel would be applied in these proceedings. And I would respectfully suggest that the reason for it is exactly this type of case where certain of the exact same charges and the exact same facts and the exact same evidence had a full and complete hearing in another jurisdiction prior to the District of Columbia even beginning their hearing process in this matter. And I would respectfully submit that collateral estoppel should have been applied and should have precluded the relitigation of those issues and those charges. And if disciplinary counsel, I believe it was actually bar counsel at the time, but the name has changed in the intervening time. If disciplinary counsel had wanted to simply charge the other incidents without any evidence and the found facts and the found issues from Maryland being applicable, that would have been the appropriate course to tread on in this matter. But that's not what occurred here. Instead, we relitigated the same issues and the exact same evidence on those matters and the exact same witnesses on those matters. And it was a wholly different decision from the trial judge in Maryland. And that's what collateral estoppel is designed to prevent, a relitigation of those exact same issues and those exact same charges. I would be remiss if I didn't point out that we raised, of course, in our brief that consideration of a lesser sanction other than disbarment is appropriate given Ms. Wild's record. And I want to make certain that I point that out. She had a career of roughly 34 plus years at this point in time. This incident and these facts have served as the only basis for any complaints filed against her. She has been appointed to a number of committees and organizations by various authorities, and she's had a career that has been accepting these matters exemplary, and that should be considered by this court in a determination of the appropriate sanction, which, if your honors uphold the findings, the factual findings, and the determination, should be a sanction lesser than disbarment. I'm happy to consider any questions that any of your honors have.
Well, I think both counsel have ably submitted their cases, and the case is now submitted, and thank you both.
Thank you, your honors.
This court is now adjourned. Counsel, you can exit.